Hello everyone, welcome to Learn Law with AKP. In today's class, we are going to discuss an important topic under Contract of Guarantee, Rights and Liabilities of Surety. In earlier classes, we understood what guarantee means and who the surety is. Now, we will understand what rights a surety gets and what liabilities or responsibilities a surety has. This topic is very important for exams as well as practice and practical legal understanding. So, let's begin. First, let's quickly revise who a surety is. A surety is the person who gives guarantee. The surety promises that if the principal debtor fails, he will perform the obligation. For example, A takes a loan from a bank, B gives guarantee. If A fails to repay, B becomes responsible. So, B is the surety. Now, let's understand the liability of surety. The liability of the surety is secondary. This means the surety becomes liable only when the principal debtor fails. Another important point is the liability of the surety is coextensive with the liability of the principal debtor. This means the surety is liable to the same extent as the debtor. For example, if the debtor must pay 5 lakh rupees, the surety also liable for 5 lakh rupees. This is a very important exam point. Now, let's understand the rights of the surety. The first right is the right against the principal debtor. If the surety pays the creditor, he can recover that amount from the principal debtor. This is called the right of indemnity. If the surety pays the creditor, he can recover the amount from the principal debtor. This is called the right of indemnity. For example, suppose B pays the bank because A failed. Now, B can demand repayment from A. So, the surety has the right to recover money paid. The surety also has rights against the creditor. If the creditor has any security against the debtor, the surety gets benefit of that security. For example, suppose the bank holds property documents as security. If the if the surety pays the debt, he can use that security to recover money. This protects the surety from unnecessary loss. Now, let's understand rights against co-sureties. Sometimes, more than one surety may give guarantee. In such cases, liability is shared. For example, if two sureties guarantee a loan of 10 lakh rupees, each may be responsible for equal contribution. If one surety pays the full amount, he can recover the share from the other surety. This is called the right of contribution. Now, let's understand an important case related to surety liability. In Swaran Singh versus State Bank of India, a person stood as a guarantor for a loan. The borrower failed to repay. The bank proceeded against the surety for recovery. The court held that the surety is equally liable once default occurs. The creditor can directly proceed against the surety. Here, the principle established is the liability of the surety is immediate and coextensive with the liability of the principal debtor. This is a very important principle. Now, let's quickly revise the important points. The liability of the surety is coextensive with the debtor. The surety has the right to recover money from the principal debtor. The surety also gets rights against the creditor and co-sureties. These points are frequently asked in exams. Let's conclude this topic. A surety is a person who gives guarantee for another person's obligation. The liability of the surety arises when the principal debtor defaults. At the same time, the law also protects the surety by giving several rights. The surety can recover money from the debtor, claim securities, and seek contribution from co-sureties. We also understood these principles through the case of Swaran Singh versus State Bank of India. So remember, liability on default and legal protection through rights are the main concepts. For exams, always remember liability, rights, examples, and case law. Thank you. If you found this video helpful, please like, share, and subscribe to Learn Law with AKP. Stay tuned for the next topic.